Ms. Katalin Sulyok, climate law scholar, advisor to the Ombudsman for Future Generations of Hungary, to please unmute yourself and present your presentation on protecting a safe climate for future generations, lessons from international courts. Thank you, Kata, the floor is yours.
Thank you, Csaba. And let me just try to share my slides. So hopefully you can see me and hear me and see my slides, more importantly. Okay, thank you so much. So good morning, everyone. I'm really happy to be here with you, even if only virtually. So the title of my talk today is Protecting a Safe Climate for Future Generations, Lessons from, and possibly also for, international courts. And in the following minutes, I'd like to talk about the power of using the future generations narrative in climate litigation, both before international and also before domestic courts. So I'd like to address three main issues. First, the past of future generations, so to say. So how international courts have treated the idea of intergenerational equity and the idea that the present generation owes certain legal obligations to the future. Then I will turn to the newest wave of climate litigation cases, where we see that courts are much more receptive towards this idea, and they started to treat future generations with real legal impact and normative impact. And in the concluding slides, I'd like to talk about the possible future of future generations, because I believe that this idea of intergenerational equity, this idea that this generation owes certain legally actionable obligations towards posterity and towards future generations, has the capacity or the potential of bringing a transformative change into climate litigation, but also potentially to climate lawmaking. So simply stating, I will argue that this soft law principle of intergenerational equity can be similar to this tiny little book that you can see on the slide. This photo features the art installation of Jorge Mendes Blake, which originally sought to illustrate the power of reading and the power of ideas. And by way of analogy, I will argue here today that the power of future generations is similar to that little book, which, as you can see, is capable of altering the structure of an entire brick wall simply by laying at the bottom of it. And I like to think, and I will argue, that the idea of future generations and their rights and interests is also capable of exerting such a transformative change in the long run. So let me start at the beginnings. So the beginnings were sort of quite dim for future generations, in the sense that even though they have been largely recognized as a moral obligation, intergenerational equity has not been treated as a normative idea for long. So in the beginnings, it has been reiterated in almost every world religion. It has been accepted by traditional indigenous legal cultures, but only as a moral obligation. It only entered the body of international environmental law with the Stockholm Declaration in 1972, where Principle 2 is talking about some correlative state obligations to protect natural resources for future generations. Later on, it has become a buzzword of international environmental law. It has been reiterated in countless soft law documents. It has also made its way into more than 30 international treaties, even though most typically into just non-binding preambular provisions. And it has reincarnated into neighboring concepts such as sustainable development, intergenerational fairness, intergenerational justice. And altogether, now the general consensus among international lawyers is that it has become a principle of international environmental law. However, if we look at the actual judicial practice of international courts, we see that international courts, even though they recognize it as a standalone principle, they have never really treated this principle as a justiciable one, in the sense that they never discerned and imposed any binding obligations on states solely from the basis of this principle. So with the famous, or rather infamous, words of the Human Rights Council in the Port Hope disputes back in the 1980s, the legal relevance of intergenerational equity has exhausted in putting in context the importance of the matter. Even though states have been referring to this idea as a source of legal obligations for decades, if not centuries. So the first instance, occasion of relying on this idea was by the US as early as in 1893 in the Bering Sea First Field Arbitration. Later on, Hungary was relying on the idea of future generations, and it argued before the International Court of Justice in the Gabčíkov-Maros case that future generations are capable or should be viewed by the court as a legal qualifier of states' due diligence obligations to protect the environment. But international courts thus far have never really picked up on these arguments in their majority findings. So from the ICJ and other major international courts, we only have certain harsh dissenting opinions, most eminently by Judge Vera Mantri or Judge Trindade, who were enthusiastic advocates for this concept as a legal concept, both at the International Court of Justice and the Inter-American Court of Human Rights. But again, in this first phase, this very long and established first phase, future generations and any obligations owed to them were not treated as legally binding obligations or legally relevant justiciable concepts, more like mere soft law, non-binding aspirations. But I also believe that this may all be about to change. And I think the first real milestone in this respect has been the landmark Klimacentrumren ruling that we've just heard about so much from Elizabeth in this wonderful presentation. I'm so inspired to talk about after this presentation. So we've heard the story, and we now know that the European Court of Human Rights declared a violation of Article 8. But what is even more interesting for the purposes of my talk today is that the court explicitly relied on the idea of intergenerational equity. Actually, this idea was the very first principle which the court invoked in its judgment when it started to set out its own justifications for finding that violation. So the cornerstone, the starting point of the court's judgment is the importance of intergenerational burden sharing, which is just yet another reiteration of the idea that we owe certain obligations towards future generations. And what is even more interesting, perhaps, is that this reference is not only a symbolic tip of the hat towards future generations. The court actually goes on to discern some real tangible obligations for states. It says that contracting parties have an obligation to adopt immediate GHG reduction measures, because this is the only way that we can prevent them from imposing an excessive burden on future generations. So we shall now see whether other international courts will also follow suit and whether they will also change their formally dismissive approach towards future generations. We have another significant case coming up before the Inter-American Court of Human Rights, which is deliberating on an advisory opinion on human rights and climate change, where two of the questions directly touch upon such issues. So one of the questions seeks to clarify the scope of state obligations towards children's and future generations, and the other one touches upon the extent of states' duties to prevent slow onset events, so future climate harm, so to say, which is again an inherently future-oriented question. And then the other potentially hugely significant decision will be delivered by the International Court of Justice, which is the Supreme Court of the UN, which is also deliberating on an advisory opinion on states' climate-related state obligations under international law. This proceedings was launched by the UN General Assembly, which posed two questions to the court. And both questions feature at their core the concept of future generations. So it is clear that as at least as far as the framers of these questions concern, the framers of these questions clearly believe that the idea of future generations is legally relevant. It has some normative implications, potentially binding implications on the scope and content of states' obligations under international law, both under customary international law and treaty law. So the first question asks the court to clarify the scope of state obligations under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic GHG emissions, both for states and for present and future generations. And the second question asks about the legal consequences of breaching these obligations, and yet again, towards other states and towards future generations. So the oral hearings are about to start in December, and we hope to have an advisory opinion sometime next year, which can have really important knock-on effects on the reasoning of every courts, including domestic courts, in climate litigation judgments. So we shall see how the International Court of Justice will frame its inquiry and whether it will change its formally dismissive attitude towards future generations. But what is clear is that there are several signs of a revival of treating future generations with normative implications that are already underway. So we have this hugely significant soft law document from 2023. An expert commission issued the Maastricht Principles of Human Rights of Future Generations, which identify several human rights that can be used and utilized in litigation and in advocacy to protect future generations. Then the UN just held its Summit of the Future, where the outcome document includes the Declaration of Future Generations. And if we look at the domestic level, we see that almost half of national constitutions do refer to future generations in some form. And what is even more important, perhaps, is that domestic courts have started to treat these references as legally binding and legally relevant and justiciable. So they are not merely symbolic references to future generations, but we have ample case law where the courts do rely and utilize this narrative of future generations in order to impose some real binding obligations on states. So I also believe that this is these duties towards the future lies at the core of climate litigation, up to the extent that we can, or at least I believe that the common legal architecture of climate litigation can be largely traced back to certain legal standards and norms based on which courts try to protect future generations from climate harm. So in the interest of time, I will only briefly mention three of such standards, which are normative avenues for courts to protect future generations. So, and this runs across different domestic jurisdictions, and these legal bases emerge as common shared litigation strategies of plaintiffs in climate litigation cases. So one of these shared patterns is relying on human rights guarantees. And we see that courts are increasingly extending the temporal scope of human rights guarantees in order to mobilize them against future harm. So we see that in some jurisdictions, courts focus on special rights holders, such as rights of children, rights of future generations, rights of indigenous peoples. In other jurisdictions, mainly in Europe, some courts are more focused on extending the temporal scope of generally applicable human rights, right to life, right to private life. Another common litigation strategy is to discern certain duty of care for states to care about the future. So again, we see that national jurisdictions vary in terms of the sources of such obligations. In some jurisdictions, it is the constitution from which courts discern some duties towards the future. In other jurisdictions, it is the common law or some statutory laws. And interestingly, we see that now plaintiffs have started to argue for similar duty of care obligations to have concern for the future vis-a-vis corporations. So we shall see to what extent they are going to be successful, but the idea is the same. So I do believe that we see a trend emerging here where state decision makers and possibly corporate decision makers are held into account, and increasingly courts are starting to crystallizing certain duties for them to care about future generations as well. A third litigation strategy is to rely on age-based discrimination standards. So the main idea here is that to or overly relaxed GHG mitigation standards in domestic climate laws amount to discrimination by impact, because actually these two relaxed GHG reduction measures allow and impose actually hugely significant and drastically disparate climate impacts on essentially similar individuals solely based on their date of birth. So the science is clear in this respect. The only question is whether these disparate climate impacts are sufficient to make a legal case for discrimination by impact. So we have this groundbreaking study published by Theory and his colleagues in Science about intergenerational inequities in exposure to climate extremes, and we see that that later birth cohorts, typically who are overborn around 2020 and later, they will experience during their lifetime unprecedented climate conditions, climate extremes that previous birth cohorts will never have to experience during their lifetime. So the question is whether we can frame these disparate climate impacts as discriminatory laws. Some claims are already pending before domestic and international courts. Unfortunately, Duarte case, as we've just heard from Katalin's excellent presentation, has been found inadmissible. So the Strasbourg court has never reached the merit stage where it could have ruled on the non-discrimination argument put forward by the Portuguese kids. But we have other cases pending before the Strasbourg court. So we hope to have a definite answer sooner or later by some courts. And in my last slide, I'd like to just offer you a glimmer of hope, because actually I try to remain optimistic despite, well, all indications otherwise, because I do believe that this idea of future generations can be a really powerful normative tool, a legal tool for litigants and courts, because it is clear that we need some novel tools, right? Because our old legal rules are incapable of handling the climate crisis. So we need some innovative results and innovative tools. The problem is that innovations do not seem to work in law. So if we look at legal innovation studies, they make the compelling argument that law is an essentially conservative exercise which values commitment to values adherence to past commitments. So revolutions do not seem to work. Only those novelties seem to work in legal regulation, which are incremental in nature. So actually, I think we are in a quite paradoxical situation where we want to have an innovative result through an incremental process. But I believe that utilizing intergenerational equity and reading intergenerational equity into binding justiciable legal obligations is actually capable of doing that. So the trend that is emerging across domestic and now increasingly international jurisdictions is that courts have started to inject long-termism, started to read intergenerational equity and concerns for the future into actual binding obligations such as human rights, due diligence, or non-discrimination, and a couple of others. I think it is capable of delivering an innovative result, because we see that courts are increasingly stepping in and they are increasingly striking down short-termist climate measures, which have never happened before. And they do so in an incremental process, because what we see is that the courts are only adding a sort of a future-oriented aspect to well-established and well-recognized binding obligations. Human rights are applicable. Human rights have been adjudicated by courts for decades. And now we see that now the courts, they only expanding and extending the temporal concepts, the temporal sort of scope of these human rights guarantees. So in a way, what they are doing is essentially an incremental process. So I'd like to offer you this sort of optimistic reading of what we see emerging from climate litigation judgments, in that courts are increasingly stepping in to protect future generations, and this can really hopefully help us rectify this short-termist bias of the current environment and climate lawmaking, which is the core feature of the current legal paradigm, which has led us to the Anthropocene, unfortunately. So thank you for your attention, and I'm conscious of my time, so I'm happy to be available for questions. Thank you.